Hi, welcome to today's webinar. I'm Mike Swanson. Our special guests today, like you as a plaintiff lawyer, have devoted their lives and careers to helping people who've often had the worst day of their life. Unlike non-lawyers like me who generally avoid tragedy, plaintiff lawyers like our guests and like you embrace tragedy in a way that is helpful and tries to get the best possible results for your clients. And so that's why Advocate Capital devotes time and energy to providing educational content to help plaintiff lawyers get even better results for their clients. It's our way of trying to make the world a better place. So we're going to have a nice discussion today, learning about tips for prosecuting birth injury cases. A few housekeeping items first. First, a disclaimer. This is an informational webinar. It's not designed to be legal or medical or tax advice. If you need help from a professional, do so. This webinar is brought to you by Advocate Capital. We are purveyors of the AvoTrack Case Expense Funding Service. We've been serving plaintiff lawyers since 1999, over 550 law firm clients now in almost all 50 states. I'm the CEO of Advocate. I wrote a book called How David Beats Goliath. It's the only training book for finances for trial lawyers ever published. If you'd like a copy, send me, let's see here, we're having the producers contact me. If you'd like a copy, just let me know. I can send it to you via PDF, or if you'd like a hard copy, I'll send that to you as well. Okay, so let's get started. I'm going to introduce our first guest, and he is Nelson Tyrone. He's an accomplished plaintiff's lawyer from Atlanta, Georgia. He has been prosecuting birth injury cases for many years. He's been a super lawyer since 2012, I think it is, and he's actually the son of a grandson of doctors, lawyers, nurses, and judges, all kinds of good things like that. Hey, Nelson, how are you?
Hey, Michael, I'm good, thanks.
Great, thanks so much for being here. We know how busy you are with cases, and we appreciate you taking time to help other lawyers out on these important types of cases, so thank you.
Of course.
Great. Our second guest today is Mr. John Lancione, and like me, John's from Cleveland, Ohio, and we've known each other, I guess, a couple of decades. John, gosh, he's a third-generation lawyer. He's been serving clients for 30 years himself, but his family has actually been serving clients for over 80 years. John, welcome.
Thank you, Michael. Thank you for having me here today. Appreciate it.
Yeah, absolutely. It's great to see you. Thank you both again for your time today. So if you're having questions today, we encourage you to be interactive. I'll be glancing at my phone every so often. I'm not checking my email. I'm watching for the questions to come through. Feel free to use the questions dialog box in your GoToWebinar control to ask questions. We'll try to do those as we go, and we'll also have a Q&A at the end. Well, before we get started specifically on birth injury cases, I was wondering if you could just share with our audience how you got to where you are today. John, for example, how did you, I think I can guess it's a family thing, but how did you become a plaintiff lawyer? Why plaintiff? Why not some other kind of law practice?
Well, growing up in a family full of lawyers, starting with my grandfather and my father, of course, as a young child, my dad would disappear for a week or two or three. And I'd ask my mom, where's dad? And she said, he's in trial. And I really didn't know what that meant. But then as I got older and he would come home from a trial, there'd be a big party at the house. His partners would be there, champagne corks would be popping, and it looked like it was a lot of fun. And then I started going to the office with him as an adolescent teenager on weekends. And then I started working in the firm as a clerk. And I saw the important work they were doing and the impact it had on people's lives that were injured from many different types of injuries. But he specialized in medicine and medical malpractice. He actually wanted me to go to medical school, but I really felt that I could do best for people and help the most people as a plaintiff's trial advocate in the area of medical malpractice.
Yeah, and I don't know if you remember, but my business partner, Dan Taussig, and I had the pleasure of having lunch with you and your dad in downtown Cleveland. It's got to be 20 years ago, something like that.
I do remember that, yes.
He's a great guy. Fantastic. Well, Nelson, same question to you. Why are you a plaintiff lawyer? How did you get here?
Well, so I'm a doctor's kid, and he was a doctor's kid. And I knew pretty early on I wasn't going to be a doctor. Math and science weren't my thing, and it seemed like that's what you needed to be good at. I started thrashing around trying to figure out how I could do what I saw my dad doing, and that was making a difference. Got a up every day, worked 7 days a week. Was devoted to taking care of folks. And I have a long line of lawyers and judges on my mother's side of the family. And it seemed like that was an area where if you tried hard enough and you got lucky, you could do some good. And so that's really what set me off down the course.
Right.
Sure.
And what a difference. Most people who are not lawyers don't understand what plaintiff lawyers do all day, right? They don't understand it. When we hire new folks at Advocate, one of the first things we do is start to deprogram them from popular culture's understanding what plaintiff lawyers do. And I ask every new employee, you know the First Amendment, what's the Seventh Amendment, right? And there's only been 2 out of like 60 people over 20 years who actually knew the Seventh Amendment. So it's just not understood or known about. So a lot of what we do is educate the general public even and through our employees about that. And we get excited that we get to support folks like you and help you do what you do, because I couldn't do what you do. You know, I'll admit that I turn off the news because I don't want bad news, you know, and rather than turn that off, you're welcoming those people every day into your practices. And so thank you for the work that you do. Super important. All right, let's talk birth injury cases a little bit, because we have quite a few dozen lawyers watching you right now, and they would love to learn from your decades of experience, because they're taking cases like that, and they would like to learn from your experience. So Nelson, let's start with you. What makes birth injury cases different from other personal injury cases?
Well, so they're big and they're complex. Other personal injury cases can be big and complex. To put perspective on it, if your average car wreck case has no experts, maybe a doctor, maybe your average trucking case has 2 or 3, and that's a big expert heavy case. I'd love to hear John's experience. I mean, we end up with about a dozen on our side of the V, as many on the other side.
A dozen?
Yeah, so you're in the high 20s, 24, 25. If they bring a genetics defense, you add a couple more. And so that's just pretty routine.
Wow.
So that's one basic way that they're different. They're big and they're unwieldy and they're wildly expensive, which I guess, brings us here with you, the whole David versus Goliath thing. So that's one way. I guess the other thing I'd like to add is that, and I don't want to scare people off from them, because here's the other piece, is that what you hope for as a plaintiff's lawyer is that you hope that you can make a difference in folks' lives.
Right.
Some days you feel like you are and some days you're not. And once you get into this space, if you're lucky enough, when we're successful with cases, it changes folks' lives forever.
Right.
A lot of money in a trust account, taking care of a child for the rest of their life and providing for them in a way that we would want our own kids provided for, with the best insurance and unlimited resources. And so you said what we do is hard. I mean, it is, it's challenging, but man, it just fills us up, the good we get to do in our clients' lives. Yeah.
John, anything you'd like to add as far as what makes birth injury cases different than your average PI case?
Yeah, I really feel they are different. They're a hybrid of all the different disciplines in medicine, because, as Nelson said, we have to have so many different experts to both prove our case and disprove the defense. So you have to have be highly specialized in the area of medicine, not only just obstetrics, but in neurology and neuroradiology. As Nelson said, we easily have 12 experts, and that starts with obstetrics and gynecology, maternal fetal medicine, neonatology, pediatrics, pediatric neurology, pediatric neuroradiology, placental pathology, genetics, physical medicine and rehabilitation, pediatric developmental medicine, life care planners, economists. All these people need to be brought together to both, as I said, prove the case, but actually when you're working the case up, you have to anticipate defenses and hire experts to mitigate those defenses that you know you can't anticipate. For example, years ago, a paper came out by a physician saying that the placenta is the new defense weapon in defending birth injury cases. Sometimes we have to order specially stained slides, recuts of placental tissue or fetal tissue. So it's just become so highly specialized that
Wow.
you really need to know the medicine. In fact, I met Nelson, I believe, for the first time at a seminar for interpreting electronic fetal monitor tracings. So learning and being a good student and always learning is what I think really sets us apart, because you cannot wing it. You cannot just rely on your experts. You have to know the medicine. You have to know what the case is about before you even go out and retain experts. And I know Nelson. I know he has that level of expertise. And there are, a handful of attorneys around the country that all work together and collaborate and share information.
Yeah.
To help each other in these extraordinary ventures that, again, as Nelson said, are very expensive and impactful on the child's life and the family's life.
Yeah, it's always impressed me when I speak to my friends who are plaintiff lawyers, how many different sciences just an average plaintiff lawyer needs to know about just for car wrecks, physics and chemistry and all kinds of different things. It's just amazing. It's fascinating. And John, you named the list of experts there. I couldn't even memorize that list, much less know what they all meant and this kind of thing. It's incredible and a little overwhelming, I'm sure, to some of our viewers who are maybe starting out. So, Nelson, or let me start with John. What would you say to somebody like that? How do they come up to speed on all these things? How do they learn about that?
Well, if I just reflect back on how I got involved and it started by going to seminars because of just the interest in this area of legal medicine, and then reading some more, attending CLEs where you have physicians teaching the medicine. For example, interpreting electronic fetal monitor tracing is a huge part of what we do. So you really have to know how to do that and not rely on experts, because we've all had a case or situation where an expert sent us down the wrong path. And so you have to know what you're looking at and what it means in order to avoid that mistake.
So a lot of reading. If you don't like to read, you don't want to become this type of lawyer. Nelson, for our younger lawyers who are watching this, what advice would you give them as far as how to come up to speed and develop their expertise?
Well, so for sure, attach yourself to somebody who's done it before. I mean, I don't mean to be in a position of trying to pitch myself as a co-counsel, and I'm not. To reflect on what John said, I got into my first birth injury case as local counsel, not intending to do much more than be local counsel, which can be a pretty easy ride. The other lawyer was with a firm and knew what he was doing and had been doing it a long time. We got about 6 months from trial and that firm disbanded. And so I started flying out to where they were to try to learn what I could. And we ended up trying the case and were successful. But even after that, for the next several years, even if a case came my way, I wouldn't have taken it on my own. I attached myself to a lawyer who'd been doing it a long time because it's just overwhelming. And I guess the second thing I would say is I'd echo what John says. I mean, I'm learning new things every day. I haven't been doing it as long as John has. I've got a labor and delivery nurse full time who works for me, and every day she's checking what I know and teaching me new stuff. So just be prepared to really dive in.
Yeah, it's not the type of practice to get into when you first hang your shingle, for sure. Lots and lots to learn.
John does other things, which is amazing to me. I can only do this one thing because again, he's been doing it a lot longer than I have. I just have to stick to this one thing and read all the time.
Right. Well, Nelson, what are some of the key strategies or techniques or things that you do when approaching a case, when prosecuting a case, to get the best results for your clients?
Well, I'd say the most important thing we do is that we know, I mean, again, not out of the goodness of my heart, but because financially and the impact on the client is so great, we don't file suit unless we are 100% certain that it's a really compelling case. And so by the time we file suit, we have every expert on board, all those dozen, 12, 13, 14, whatever the number is. They've all done their work. They've given us, we hope, a conservative review and set us away from cases that we're not going to be successful with. And we have all of that done before we start. And so not only does that help us make sure that we're only bringing really compelling, legitimate cases, but it also allows us to be on offense from the start and know what our case is, what we anticipate the defenses are. And that's just very different from the way that I was able to practice in a more general plaintiff's practice, where we did review the case, we did believe we were on the right side, but there were often things we were figuring out through the litigation. I don't think you can do that in this area. You'll get curveballs thrown at you, but you really need to expect 9 out of 10 of those curveballs ahead of time.
Yeah. John, what are one or two things that you do, key strategies?
I would repeat everything Nelson just said to you. One of the strategies I use is to have the case ready to basically try before I file it. And many times, pre-suit, I will reach out to the hospital counsel and the doctor's insurance counsel and offer them to entertain pre-suit resolution. And that has been successful in several cases, because when you're ready to go, when you have expert reports and you have your case put together already and it's airtight and rock solid, some of the more altruistic and ethical companies or entities, hospital systems, will want to avoid the expense of litigation.
Yeah.
Because we have one set of experts. They may have to have a set of experts for a nurse, for a doctor, for a neonatologist, who may all have been involved in this delivery and the adverse outcome to the child. So that's something I employ in every case, because as Nelson said, you've got to be near 100% certain that the case has merit and that you have a high likelihood of success at trial before making this monumental undertaking.
Wow. So you're working the cases up in their entirety, essentially, before you even file suit. Does that make it easier after you file suit, since you're already done, kind of?
Yeah, you have your roadmap already planned out. It makes preparing for depositions a lot easier. You have your fetal monitor strips annotated, so when you go into a deposition, whether it's a 30-page strip or a 300-page strip, it's ready to go for the nurses who interpreted it, and it reduces the time in deposition. And I think it makes the depositions more successful from an advocacy standpoint, because you've already done the work and you don't have to spend all that time with a nurse or physician under oath and on a video camera in a deposition. Right.
Nelson, anything else that you do that's special about birth injury cases?
Well, I wouldn't say special, but it's easy to get lost in the medicine. So you have to master the medicine for sure. You're going to have to meet all of these experts in their fields of specialty and go toe to toe with them and know not as much as they do, but know a lot. But then you've got to get it to the point. You've got to know it well enough to get it to the point where you can explain it to an average person off the street. And so that, to me, really underscores what John's talking about, is that we do all of that work ahead of time. And then as we're doing that work, John's done this for years and years longer than I have, but as I'm doing that work ahead of time, it seeps deeper and deeper into my brain, and I'm able to explain it in a simpler way. If you ever think about maybe the best teacher you ever had in school, they weren't the ones who confused you. They were the ones that took confusing things and made them simple. And at the end of the day, we've got to get through all of this very high level, convoluted medicine, and all of the defenses that they're throwing at us, and get it down to a story about missed opportunities, failed chances, no backup system, those kind of human stories that our jury can understand.
Yeah, telling a story. It's almost a foreign language, medical is. My dad was in the hospital recently, and just trying to talk to the nurses and doctors, I had to keep saying, well, what does that mean? What does that mean? The jargon and all this kind of thing. And, it's really confusing. So Nelson, when it comes to juries, how do you approach voir dire? How do you approach making these things plain to juries?
I don't know that I have anything that I do differently. In fact, I don't think I do anything differently than I did from my general plaintiff days. I was schooled in the Jerry Spence method, where we really approach it trying to show our own fears about the case, and just I've heard other lawyers talk about this. You know, the dead cats, the thing that you bring into the courtroom that everybody can smell that you just wish wasn't there. And so the challenges in your case, it would be maybe a more polite way of talking about it. And I try to lay that out for the jury so we can have an honest discussion about it. My belief is that if we can't talk about it now, I'm never going to get a chance to engage them, ever. I'm never going to get them to talk back to me until they've rendered the verdict. And maybe the judge lets us pull the jury and talk to them. And that is not the time to figure out, like, if you're going to lose your case or why you lost your case, or did you want this juror on the jury. So I really try to have an open discussion with them as much as the court will allow me. That's my approach. The only thing that I'll add to that is I haven't pulled this, and I would love to hear John's view on it, given his years of doing this. But I don't think that we hold doctors on the kind of pedestal that I think we did when I was growing up. I think we've all experienced, Michael, what you were talking about, where it's all just very unsettling and it's kind of over our heads. But we've also experienced delays from the system. We're not often getting much time with our doctors. And so I feel like that benefits us in that at least I look at doctors as human now, and just as fallible as me or anybody else. Yeah. Growing up, I don't think I looked at doctors that way. I don't think it was just being a doctor's kid either.
Yeah. Yeah, absolutely. And until I was maybe 18 or 19, I thought all adults were equally intelligent and, sure, knowledgeable and things like that. And then you realize you go to college and have some professors and you realize, wow, some of these professors aren't really even that sharp, what have you. John, what's your experience, your approach with the jury? Anything in particular?
Well, I believe that most, if not all, cases are won or lost in jury selection. I just attended a webinar last week with a colleague from Colorado who tried a case in Ohio down in Cincinnati for 6 weeks, and it was tried to a hung jury.
Wow.
And they got to talk to the jurors after the trial, after the jurors were dismissed, and one of the jurors said that point blank to him. He said, "You lost this case in jury selection. Why would you leave those jurors on this case?" And the jury consultant said something that I have known for a long time because I've worked with her and other jury consultants. And you've got to ask the question point blank. You've got to say, some people think that doctors should only be held responsible if they were drunk, cut off the wrong leg, or hurt the patient intentionally. How many feel that way? And then you talk to each one of them. Tell me about that. And when they stop talking, you say, tell me more. How many agree with him? Ms. Smith, you agree with Mr. Jones. Tell me about that. And you get those jurors off for cause in Ohio. We have a fairly liberal cause challenge statute in Ohio. So if the judge has any doubt about the juror's ability to be fair and impartial, they have to remove them from the jury for cause. So, it's not jury selection, it's jury deselection. We're trying to get the worst jurors for us off. Some jurors are going to say great things and indicate their feeling and what's in their heart, that they're going to be a good juror for you. And the defense is going to get them off with either a peremptory or a cause challenge. Right. But you've got to get the bad jurors talking, and you've got to get them to get the other bad jurors talking and find a way to get them off for cause.
Interesting. Now, do either of you ever use focus groups?
Oh, sure.
In every case.
Yeah. Tell me about that, John.
Multiple focus groups, pre-suit. You want to see if some of the warts your clients have, and everybody has warts and things they've done in their lives that they're not proud of, and there may be a legal record of in a criminal court. So you want to focus those issues and just before you even commit to the case and file it, you want to focus the bad issues, and then as the case goes on, Focus groups are fantastic in helping you develop themes and recognizing things that you just didn't recognize. And these jurors, they come up, or these focus group participants come up with so many good things to help you create themes and sub themes, things that you want to ferret out with jurors, things you want to ferret out with witnesses and the defendants. So I think they're an integral part of what we do.
Yeah. Let me pause just for a moment and say to our audience, if you have questions you'd like to ask of John and Nelson, use the questions dialog box in your GoToWebinar chat controller, and we'll get to those here a little bit later. But if you want to start entering those, we'll be sure to get to them for you. Nelson, same question. Tell me about how you use focus groups.
Yeah, I would never try a case ever. I can't remember. I hope maybe ever I've tried a case without doing multiple focus groups. I'm not willing to let the first time I know how jurors really feel about my case to be when have already rendered their verdict and I'm talking to them afterwards, whether I won or lost. So I love John's idea of freaking cases before we file. We aspire to that. I can't honestly say we do it all the time.
Mm-hmm.
We do, let me say this, I've just discovered over this last year that I don't necessarily have to be in the room, and I'm not as important in being in the room, whether it be for meetings or depositions or other things. I've learned a lot about, I think, being humble in that regard, and I'm not appearing in all my depositions in person the way I used to. Still some, but certainly not in the past year. And we've just done our first Zoom focus groups, and they were the most efficient I've ever done. I think I got just as much from them. They were less expensive.
Yeah, for sure.
And we've done them before, and so that's something that we're really exploring, is doing, Zoom focus group or something other than having to have 10 or 20 people show up in person in a conference room.
Yeah, time consuming and expensive, I'm sure. Well, maybe you each might have an example of a mistake or mistakes you've seen plaintiff lawyers make when it comes to birth injury cases. Nelson, have you ever had that experience, heard about a mistake or the mistakes our watchers, our viewers should avoid?
Never made a mistake of any kind.
No, not you, other lawyers. Other lawyers that you heard about. No, I'm not going to ask you, what mistakes you made. No, I'm not asking you that.
Yeah, I've made a bunch, and I'm happy to share. I'm just trying to think of one that would be really.
Well, I'll throw it to John while you're thinking. John, have you ever observed mistakes or known about mistakes that lawyers have made?
Yeah, I think the area where I see the most mistakes are lawyers take a case and they really don't have the knowledge and expertise to litigate it properly. They file the case. They may not file against all the right defendants. They don't know the medicine, so they don't know the right questions to ask of the defendants. And then they realize that they're 6 figures into the case and it's going to cost maybe 3 or 4 times that to get it to trial. And then they come to you and ask for help. And then you are there to either pick up the pieces, try to fix it and glue it back together, or recognize that it's too far gone, or it didn't have merit from the beginning and it should be cut loose. So that's one area I see a lot of mistakes in, is just lawyers thinking they can, because they're a personal injury lawyer and they've handled car wrecks or maybe more high-end cases like truck wrecks, they feel they can do that. And then when they get into it, thankfully, most of the time they recognize they've made mistakes and they need assistance. Yeah,
my experience working with plaintiff lawyers for the past 20 years is that taking a case you shouldn't take, case selection is crucial, to not take cases that aren't going to pan out. But also, one of the common things I see lawyers doing is taking cases that they shouldn't, not just because of knowledge, but because of financial wherewithal. And, the reality is that we're running small businesses and we can't print money in the basement like the government can. And, the reality is there's payroll to be met. cases compete with each other within the practice for resources, limited resources, financial and otherwise. And but I would imagine in this type of case specialty that until you realize how much you have to know, it'd be easy to take a case and think, well, you know, I've bluffed my way through other things. I'll figure it out on the fly. Nelson, have you seen any of that too? Have you had folks come to you?
I think I've lived it. I mean, I think I've made all of those mistakes myself. I've certainly seen them in other folks too. The financial part of it is, I mean, it's just, I think I was naive, frankly, when I first got into this area about what the travel would require. I'm doing less of that with Zoom, I think, and will continue to. And I was naive about the cost. I mean, the cost is just enormous. And that's for a pretty straightforward, if I could say that word, you know, a very strong birth injury case. The expenses are hundreds of thousands of dollars, you know, multiples of hundreds of thousands of dollars. And so then for every challenge that you're willing to take on, I, like most plaintiffs' lawyers I know, are willing to take on challenges and try to steer them down. We also try to spend our way out of it by getting more experts on board and coming up with more creative approaches and buying demonstrative aids and animations, and all of those things can just balloon the expenses of the case. And so that's the biggest mistake that I personally have ever made, is not really appreciating the significance of some challenges, defenses that I identified early on. What that would require in man hours, team hours to overcome, and what that would require in expense to overcome. And it doubles your case expense if you take on, you know, too many challenges in a case.
Right, absolutely. Yeah, it's I've always said here at Advocate, we have the easy part. We're focused on the business and this kind of thing, and you all are doing the heavy lifting. I've not been to one of my clients' conference rooms that doesn't have a box of tissues in it as well. I'll start with Nelson this time. Let's talk about that emotional impact. How you deal with that, and speaking with, you know, folks who've had the worst day in their life recently happen to them. What's that like?
Well, I'll give you two answers. One is that when we take cases on, as John said, we've done the work ahead of time to know that, to believe that we'll be successful, high percentage that we'll be successful. And so we're always fighting for that. And when we are successful, it fills us up and makes it worth it. It's the clients we can't help that really get it to you. And on those days, I just leave the office, you know, maybe a little early and go home and hug my kid. It really, if you ever needed anything to remind you of how grateful you should be and how full your life is and how thankful you should be,
right?
It's this kind of work, because it involves, you know, our clients, these are almost always these little babies. Sometimes they're mom, but almost always little babies who will need care their whole lives, never live independently. It just can rip your heart out, particularly when you know that there's not a path forward for them. And so that, I feel like I'm repeating myself, but that's what's the toughest for me, are the folks who help, because there's no real upside of that. It doesn't feel successful at all.
Thank you. John, what advice do you have for newer lawyers who are looking to take these cases on in terms of the emotional impact on yourself and your team?
Well, I think as trial lawyers, we all have a little more emotion and sensitivity toward people who suffered a catastrophic loss or injury. So you have to have it in your heart, I think, to really engage in these cases and litigate them with passion. So you have to look within your own self and your own soul and say, you know, are my emotions, number one, going to help me and not be an impediment? Number two, am I going to be able to recognize and deal with my clients' emotions. As you said, there are tissue boxes in conference rooms and offices, and I've cried many times with my clients. Every time I read a letter I got from a client whose daughter died following birth of her third child from severe preeclampsia. They kept her alive for a week so the tissue or the organ donor company could determine what organs of hers are suitable for harvesting and giving to another person. And all the people that got her organs wrote letters to this woman, the mother of this young lady. And it's the most gut-wrenching thing you'll ever read in your life. I have it up on my wall in my other office. And, I think that's part of what drives us and motivates us to do well for people that have meritorious claims is the justice in it and the emotion as a human being that you feel to motivate you to make you get up at 4 a.m. and go to bed at midnight and, spend 3, 4, 6, 10 weeks in trial away from your family. That's a big part of it. And I think younger lawyers have to look within to see if they have that, which is going to be an asset to them through their career.
Yeah. Wow. Guys, I got to tell you, I wish I was half the man that the two of you are. I don't think I could do it. And I'm very thankful that there are lawyers like you. First of all, contingent fee lawyers generally, because what good is a Seventh Amendment without a contingent fee lawyer? They are the keys to the courthouse, and folks can't afford to hire a $400 an hour lawyer or whatever that costs. So, but there are folks taking these cases. My son was 5 weeks premature, and he's fine. He's healthy now. He's 32 and has his own family. So I had a happy ending. But if something had happened to him, crazy. Well, we sure thank you. We're going to do a Q&A here in just a moment. So folks, if you're watching and you have questions, please enter them in the dialog box. What advice, John, would you have for either a lawyer who's looking for someone to help them partner, share a case, but even a consumer who might be watching this and thinks they might need a birth injury lawyer? What are the kind of things they should look for?
Well, today in the age of the internet, you can find out anything you want about anybody by looking at the law firm's website. Before the age of the internet, I would go to, as a young lawyer, almost right out of law school, I would go to seminars and listen to the stalwarts talk about birth injury cases. And one of my personal mentors, Les Weisbrod from Dallas, Texas, I followed him all around the country to seminars, just listening to him. I'd be in the front row listening to him talk about his deposition techniques and strategies, and then I'd get my hands on every deposition I could that he had taken of either defendants or experts or trial transcripts, and kind of incorporated into my style his theory of total devastation of the witness. So learning from the people, we stand on the shoulders of those that came before us, and I believe that. Yeah. And much of what I've learned is from following, listening to, and reading the works of other great litigators in this area. So that's one piece of advice I would give a young lawyer.
Mm-hmm. Nelson, how about you?
100%. Use the word copy. I think study under, tutor, mentor, have someone to mentor you is probably a more accurate way to talk about it. I chuckled because, boy, I'm a fan of Les's too, and I think he approaches his depositions with total devastation in mind, and so I chuckled at that. That's what I do. They're lawyers who speak at conferences and who teach conferences that I'll go anywhere at any time and put everything else on hold to be there to learn from them. And I know, I'm sure John feels the same way. I feel better. I'm able to sleep at night knowing that I'm doing everything in my power. I'm still going to make mistakes. I'm still not perfect.
Sure.
But I sleep better at night and can do this kind of work because I know that I'm standing on the shoulders of giants, the way John talked about, and I'm doing everything I can to study under them.
Right. So a question from the audience. Thank you for the great info. My go-to economist has retired. Would you mind sharing who you like for this part of the case and why? And
I'm learning from you. I'm sorry, I don't need Michael to jump in, but I
okay.
learned something.
Either of you want to chime in on that?
Oh, sure. So as years have gone by, the economists that we normally use have retired. So there's a professor of economics I use in Granville, Ohio, and I've used him on every case for the last maybe 15 years.
Wow.
He's retired now, but still qualifies, at least in Ohio, to testify as an expert. His name is David Boyd.
Boyd.
From Denison, Granville, Ohio, Denison University. Does a great job. He presents well. I've had him testify several times at trial. He does work for plaintiff and defense firms in Ohio, so they really don't want to beat him up much, and there's not much they can really use based on his theory of reduction to present value, which we have to do in Ohio. But he's very efficient. He'll take a life care plan and turn around to an economic report in a week or two.
Great. Well, thanks for being willing to share that. Nelson, anybody else's name you want to throw in?
Well, so maybe a little bit on the other end of the spectrum, an expert out there that is well regarded and very creative in his communication is Robert Johnson out of California. And he is a compelling, wildly communicative expert who, in my experience, has really helped the jury understand how what we're asking them, at least in Georgia. Let's talk about life expectancy, right? Life expectancy has an impact on these life care plans. Well, he's able to talk about them being, a minimum life care plan, because in our standard in Georgia is the life expectancy chart that folks use is 50.01% of folks will only live to this age. And so he is able to talk about why would you get in an airplane to fly across the ocean? You might have 50.1% of the fuel that it needed to make it. And he frames the case in a different way. And so for the right case, if your jurisdiction will allow it, his approach to asking the question, what happens if the money runs out, is one that really speaks to me.
Great. Well, thanks for sharing that. I'm sure our viewers appreciate that very much. What is the future for tort reform look like for birth injury cases? Nelson, do you have anything to comment on that?
So I live in Georgia, and every single year, our Republican-controlled, whatever side of the aisle you're on, legislature presents a bill. There's one insurer who insures doctors in our state. So the doctors are pretty captive, and the tort reform movement is well funded. It's probably the most well funded movement in our state. And so every single year there's a move to enact some tort reform. We beat back caps, and the Supreme Court in our state has ruled unconstitutional. But every year the legislature tries to chip away at either shortening the statute of limitations or finding some way to cap damages. During COVID, they increased our burden of proof so that we had to prove cases by gross negligence standard, whether COVID had anything to do with your client being in the hospital or not, or whether it affected their care in any way, shape, or form. And so it's a battle here every year, for sure.
John, how about Ohio?
Well, we've had caps in Ohio since 2003. I remember probably when I was in high school hearing my dad complain about damage caps and limitations on plaintiff malpractice victims' rights. He was going down to Columbus to testify before House and Senate committees. I did that in the late 90s. Our Supreme Court had always struck down caps as unconstitutional. Then when they couldn't beat us in the Supreme Court, they decided to buy the Supreme Court. So we always had a Democratic majority Supreme Court in Ohio until 2002, when they focused on the Supreme Court because they had the General Assembly. So they went and spent tens of millions of dollars, if not more, and were able to get a Republican majority elected to the Ohio Supreme Court. So they passed another cap on damages. And when I was down at the State House with our team negotiating the damages cap and other tort reform provisions, we had had them agree to $1 million cap for pain and suffering. Then when we came back after the election and they won, they had a 5-2 majority. They said, we're going to have the cap be 250. And I said, well, I thought we agreed on $1 million. And he said, well, we won the Supreme Court. It's 250 now. That cap has never gone back to the Supreme Court. The plaintiff's bar has been very cautious about bringing it up because we at one point had a 6-1 majority, conservative Republicans in the Ohio Supreme Court. Now we're trying to chip away at that and have had some success. It's now 4-3. So that case may come up again, but the defendants and insurance companies like to negotiate on caps. We take the position in Ohio that they're unconstitutional and we don't negotiate settlements based on caps. And no, sometimes it works, sometimes it doesn't.
Yeah. Well, thank you for your courage, your energy, the time you've spent over several decades to help birth injury victims and their families. Last question. How does what you're doing, John, we'll start with you, make the world a better place?
Well, I look at that question from several perspectives. From a general societal standpoint, we're taking the financial burden of taking care of a child for the rest of his or her life and putting it on the responsible party and not on society. I'm sure every state like Ohio has a Medicaid payback statute and then, of course, the Medicare payback statute. So I just told a client yesterday about the subrogation issues with Medicare and Medicaid, and that we've paid them back millions and millions of dollars over the years. So we're putting the financial burden where it should be. And second, we're making people breathe easier because of what we're able to do for them. We take some of that stress and burden off them. I had a client, one case years back, where it was egregious care. This young child, male child, was grievously injured, and his dad was absolutely devastated. It was their first child and his only son, and he cried most of the time when we were together. He never smiled, never cracked a smile. We were able to get the hospital to settle before trial for a number that was more than adequate to take care of this child's needs. The OB did not, his insurance company didn't want to settle, so we went to trial against them. And they only had a certain amount of insurance coverage, and they wanted to settle. They wanted to pay us a little bit less than their insurance coverage. And the client said, no, I want the entire thing, and we're taking it to a verdict. So after about halfway through the trial, they threw in the rag of the white towel and offered their full policy limits. And when I went back to tell the parents that, the father, who was about 6'5", 300 pounds, first time I ever saw him crack a smile, and he picked me up and started to cry and hugged me. Wow. And so to be able to bring that kind of relief after such devastation, which is unimaginable to any of us who've never been there, that's one of the things I think that that we do that makes a difference.
Yeah, absolutely. Well, it's hard answer to follow, Nelson. Do you want to add to that? What's your perspective?
John is tough to follow in a lot of ways. Yeah, I echo all of that. I think mostly what fills my heart is helping one client at a time. As he was talking, I was remembering a dad who, boy, it was a tough client. And it just felt like every single time we engaged it, we were arm wrestling. Felt like we could argue about where to go to lunch. I don't know that we ever went to lunch, but just one of those. He was a very stalwart business guy, wanted to negotiate everything. And then we settled his case, his son's case, profoundly brain injured little guy. And I called him a week or two afterwards and just to check in on him. I may have had a detail to check in about the case, and there was just a different tone in his voice. I said, how you doing? His name was John. I said, John, how you doing? And he said, Nelson, I've spent my son's whole life being terrified that I would die and that there would be no one to provide for our family because mom couldn't work, right? Mom has to be at home caring for the child. And he said, now I don't want to die, but if I die tomorrow, my family's taken care of.
Yeah.
And so my world is different. My son's world is different. And so that really speaks to me. I forget sometimes about, I'm a parent. I shouldn't forget. You know, our kids are everything to us.
Of course.
Yeah. And so that's the main way that we make the world a better place, I think, is by
Awesome.
bringing mercy to these families. Yeah.
Yep, absolutely. Well, you can see Nelson's contact information on the screen, I hope. I'm attempting to share that. And of course, this webinar will be produced as a video. So you get a link if you've been watching this, you'll get a link to the video later in case you want to refer back to that. And here is John Lancione's contact information. If you'd like to reach out to John, have a question about a case or some advice you need, this is my contact information. If you'd like a copy of How David Beats Goliath, I'd be happy to send you a copy of that. For more information about Advocate Capital, visit advocatecapital.com. And we thank you very much. Gentlemen, thank you so much for your time today. I know that you have cases you'll be working on 5 minutes from now. Thank you for the work that you do for your clients and for making their lives better. And we appreciate your time so much. Thank you.
Thank you, Michael. Thanks for having us.
All right, take care.